Good evening, everyone. I have chosen Journal 6, in which I examined two cases from Chapter 21 that are closely related, and both were instrumental in outlining what should be required of a juvenile proceeding. The first case in question is Kent v. United States, 383 U.S. 541 from 1966, in which a 16-year-old boy was arrested, questioned, and admitted to housebreaking, robbery, and rape, all without presence of counsel. The juvenile judge then waived his case to adult courts without a hearing and not allowing his counsel to view the records that were considered in this decision. He was found not guilty for the rape by reason of insanity and convicted on the rest of 12 charges and sentenced to 30 to 90 years in prison. By the time the Supreme Court had received his case and reached a decision overturning the original waiver, he was over 21 and could no longer be tried as a juvenile. But his waiver was ordered to be reviewed as if it had never happened, and he be retried, though still in adult courts. The second case, in Rigault, 387 U.S. 1, 1967, a 15-year-old boy was arrested and remanded to a facility before his parents were notified. A hearing was held the next day, in which the petition filed did not hold any actual facts, just that he was a juvenile delinquent, and his family was never informed of his right to counsel. He was then sent to the Arizona State Industrial School until 21, all over an obscene phone call. All Arizona appeals courts, to include the state Supreme Court, upheld the ruling, but the Supreme Court of the United States overturned it due to his not receiving proper and appropriate due process because his proceedings were unfair in nature. They stated in regards to both cases during this hearing, there is no place in our system of law for reaching a result of such tremendous consequences without hearing, without effective assistance of counsel, without a statement of reasons for the action taken. That was taken from page 457 of Kripe, Perlman, and Koziak, 2013. Because of these cases, there is now an outline of what must occur in a juvenile hearing for it to be valid. This list is clear and concise and should never be confusing to anyone educated enough to sit on the stand, though I am sure that some oversights have occurred since then and those involved were reprimanded. These cases have helped juvenile prisoners' rights evolve. It is important to understand that juvenile laws are in place to find the best course of action for each individual juvenile, and that a one-size-fits-all approach will only impede the purpose of juvenile courts, which is to help the juvenile, not punish criminal behavior as in a criminal proceeding. No matter what, I agree with the courts when they said that to sentence a juvenile to an institution, no matter what it is called, where their home will be a stark white institutional facility based in overbearing for a number of years, is tantamount to sending them to prison and should never be done with such little regard given to the hearing that puts them there in the first place. To place these individuals in adult prisons raises the risk of them becoming career criminals instead of getting them the help they need to prevent a recurrence of their actions. It also disrupts management of the prison they are now detained within, distracting from the purpose of the prison system, which is to reform adults of their criminal ways because they now have to handle minors in the facility. They cannot shower with other inmates, they cannot work with other inmates, they cannot do a lot of different things with inmates due to them being minors and certain rules of impropriety that are involved and cannot be avoided. The court system in these two particular cases, however they were placed, were just in too much of a hurry and not paying attention to what they should have been doing in the first place. These particular cases should never have happened in the first place due to the fact that somebody just got in a hurry and couldn't handle, taking care of a case. If you have any more questions about these cases, you can either Google them or you can find them in our textbook, Legal Aspects of Corrections Management, from 2013 on page 457. Thank you.